Let's talk about the government's power to punish and censor people for speaking words that are so offensive that their mere utterance tends to incite an immediate breach of the peace, also known as uttering fighting words. So fighting words is a confusing doctrine. Courts have produced inconsistent results, but fighting words are generally not recognized as protected. So the U.S. Supreme Court in Chaplinsky versus New Hampshire made a decision on this. It was in 1942, and it was written by Justice Frank Murphy. It was a 9-0 decision, unanimous. So basically, a statute was under fire in that decision. Chaplinsky was convicted under that statute, and that statute, it was a New Hampshire state statute. It said, no person shall address any offensive, derisive, or annoying word to any other person who is lawfully in any street or public place, nor call him by any offensive or derisive name, nor make any noise or exclamation in his presence and hearing with intent to deride, offend, or annoy him, or to prevent him from pursuing his lawful business or occupation. So Chaplinsky argues this law is vague and indefinite. And what exactly did Chaplinsky do that got him convicted under this statute? So he had been distributing literature on the streets in the afternoon, and members of the local citizenry complained to the city marshal, telling them that Chaplinsky was denouncing all religion as a racket. And when that marshal went over to Chaplinsky, Chaplinsky ended up calling him a damned racketeer and a damned fascist. Yeah, so not very nice, not a very kind guy, very offensive thing to say. So he ends up getting convicted at the trial court level. This makes its way up to the U.S. Supreme Court, and the Supreme Court holds that the limited scope of the statute doesn't violate free speech. They say that free speech is not absolute. And of course, this is the start of them really starting to recognize some of those exceptions, or at least an early version of it, because a lot of this First Amendment doctrine ended up developing later in the 50s, 60s, 70s, 80s, 90s. It's still developing today. So Murphy writes, there are well-defined, narrowly limited classes of speech that can be punished. These include the lewd and obscene, profanity, the libelous, and the insulting or fighting words. And a lot of those types of speech, like obscenity, they'll be more well-defined in later Supreme Court cases like Miller. Those by which their very utterances are so offensive that they tend to inflict injury or tend to incite an immediate breach of the peace, and those types of words which they are no essential part of any expression of ideas, have no or very slight social value as a step to truth that may be derived from them, is clearly outweighed by the social interest in order and morality. So the idea is we're basically getting nothing from them. We're getting nothing from them but insults. People are just being hurt by these words. And it's not so much that we're clutching our pearls about the idea of hurting people's feelings, because the First Amendment is supposed to prevent stuff like that. It's more so that we're recognizing this is just going to cause people to fight, and we don't want people to fight. We do not want violence in the streets. We don't want people getting the crap beaten out of them or just knocked dead or thrown down a manhole or something. So it's not so much that the speech is offensive, but that it might incite a fight, and we don't want to incite fights. Physical violence, bad. So yeah, it's kind of a fine line. Like, are we saying, oh, it's so offensive, we need to censor it? Well, no, not really. We're saying it's so offensive that might cause a fight, which is why we can punish it. And that's something that, the judges get the full discretion of deciding, especially the U.S. Supreme Court, because nobody reviews the U.S. Supreme Court. And something that's really important to note here is that scholars have pointed out how there have been very inconsistent results in the application of the fighting words doctrine, very inconsistent results on what is and is not protected when it comes to fighting words. So yeah, there have been cases where they've said some stuff that really, really is likely to start a fight that you would think would fall under that doctrine, does not actually fall under that doctrine. And different courts in different jurisdictions have gone the other way. Or they've said, hey, actually something which is less offensive than that which was said in another jurisdiction held not to be fighting words is fighting words. So yeah, it's not necessarily, it seems like an outdated doctrine in a sense. So if you're a law student, I wouldn't expect to be tested on this heavily on an exam. If you are tested on it, I would note in an essay that there's a question as to whether or not this doctrine is really defunct, if it's still good law. Would the justices on the U.S. Supreme Court be sympathetic to it? I don't know. Maybe when it suits their politics. Maybe when the person doing the insulting is of a political opinion that is similar to a majority of the justices, something like that. But yeah, it's it's never been overruled. Chaplinsky has never been formally overruled. There have been cases in the future where they've declined to apply the fighting words doctrine, like in O'Brien in the early 1970s. But yeah, it's a strange case. I think it would have come out differently in 2025. And in fact, I pretty much know it would have come out differently in 2025. But yeah, it kind of goes to show how they don't have much tolerance for this type of nonsense. They're like, hey, dude, you just called this guy a racketeer and a fascist. That's not going to help anyone. You're just shouting. And it was his opinion, to be fair, but it just seems like it's like, okay, hey man, fight me. I don't like you. You're bad. You're a fascist. He also said, like, this whole town is damned fascists or something like that. So really, also consider the historical context. This was the early 1940s. Fascism was taking the world stage. We were fighting against fascists in the form of Adolf Hitler and Benito Mussolini. So yeah, it would very much make a person's blood boil in the United States to be called a fascist. It still does for most people, but back when we're at war with them, there's a special extra injury that it would tend to inflict and a special extra likelihood of starting a fight that I could see the Supreme Court really being worried about in this context. But yeah, I hope that this video was helpful to you if you're a law student, if you're a high school student, if you're an undergrad and you're studying First Amendment. This is really interesting stuff, seeing how the doctrine has developed. As always, please like, comment, or subscribe to the channel. I'll have more videos on the law in the future. Thank you so much for watching. This has been the More the Merrier, and I look forward to speaking to you in my next video.